2, 3, 4, 5, 6, 7, 8 had called and said she would not be coming today because she has a stomach problem. And I called all the councils, and Mr. Boland came up. I told him, and then when I saw Ms. Manuel, I told her Rosemary Murphy would be the replacement. So I don't think there's much anybody can say about that. Mr. Boland?
No, no.
Ms. Manuel?
Could we just have put on the record?
Sure.
Deputy
Grissinger. And if you want, I can have the juror services person who talked to Deputy Grissinger who said it wasn't like, can I be excused? I'm not coming. So
I guess whoever spoke to the actual juror, if we...
That's somebody from juror services. Can we find out who that might be?
Yes, that would be Linda Canessa.
Okay. Thank you. Mr. Ellis, you were smart in saying we should have 4.
You said it first, so I just follow up.
I don't remember. I was thinking I had 2 or 3.
Judge, there's another issue that I thought of too.
Before we deal with this issue?
Well, I can just let you know now. We can deal with it in a minute. We didn't make inquiry of the defendant not testifying in the defense case. And that's something that I thought of that we need to make sure that we do
right.
that.
Okay. You're so right. Okay. Ms. Manuel, I'm going to need to talk to Mr. Jonchuck about that. I guess I can remedy it.
we just need a moment to explain
Sure.
to him.
Thank you.
And obviously would agree they can reopen their case and do that.
Oh, absolutely.
Might need a deputy to step into jury 1 and tell them to stand by their phone. I'm going to call you at 46680.
Would you all be satisfied with phone, or do you want?
Linda there.
Phone's fine, Judge.
Well, if,
Phone's good.
yeah, I'm going to need her to come up to courtroom too.
Phone. I'll agree to phone.
And put on the record.
Jocelyn.
Agree to phone. You can do a phone on her. She wants to testify by phone.
Okay, well, yeah, right. If she can do it by phone also. What number do you have here?
I have a number.
Let's see, you call 47159. Nope. Yeah. Hold on a minute. Yeah. You can look. Got a display for me. Yeah. All right. All right, thank you. What do we do, Jocelyn? Yeah, you want to take a call for one of my jurors? Okay, I'm gonna put you on speakerphone, all right? Can you hear me now?
I can hear you.
All right, you're on, in open court from courtroom 2. Linda. Oh, your last, go ahead and state your name, Linda.
My name is Linda Canessa, C-O-N-E-S-A.
Okay, Ms. Knessa, this is Judge Hollinger up in court. And
Good morning, Judge.
Good morning. My understanding is Juror Evelyn Lloyd, for lack of a better term, called in sick this morning.
Yes, she called early this morning, letting us know that she had some kind of stomach issue. She had hoped that she was going to feel better, but she hadn't.
Okay, did she indicate to you that she wasn't coming?
Yes.
Okay. Any questions from the defense?
No, Judge.
Any questions?
No, Judge.
Okay. Thank you, Ms. Canessa.
My pleasure, Judge.
Bye.
Thank you, Dave.
Bye-bye.
Okay, so is there any objection to the replacement of the juror that's not hearing, not coming in sick?
No, we don't.
Okay, so that will mean that Rosemary Murphy will take her place. And Rosemary Murphy is number 2248, and Evelyn Lloyd was 2021. So she'll be moving up into 2021's slot. Is Mr. Jonchuck ready for me to have a conversation with him about something I should have had last week?
Yes, Judge.
Okay. Mr. Jonchuck, you don't have to stand if you want to, if you want to. Do you swear or affirm tell the truth?
Yes, Your Honor.
Okay. Every defendant in every criminal trial has the right to testify or not. You know that, right?
Yes, ma'am.
And your time to testify in the guilt phase, for lack of a better word, just meaning before your lawyers put on their sanity case, would have been whenever the state rested. And if you wanted to testify, you could testify, because I don't think there are any other defense witnesses, right? For the actual.
We called a few witnesses.
Who'd you call?
We called Ms. Torres, we called Ms.
Oh, that's right, I'm
Jonchuck,
sorry.
we called
Yeah,
some
so-
officers.
I'm sorry, because I was figuring them in the sanity. I didn't. Okay. So obviously you could have testified if you wanted to,
Right.
right? And I should have asked you and I didn't. Do you want to testify?
No, ma'am.
Are you sure?
Yes, ma'am.
Okay. Is anyone forcing you or coercing you?
No, ma'am.
And you're making this decision of your own free will?
Yes, ma'am.
Okay. Okay, thank you. All right, so then there's this motion about Dr. Burston testifying to catatonic violence.
Yes, ma'am.
Yes, and I've read it. Is there anything else you want to say about it? And you want to be able to redepose it, right?
Yes.
Okay.
I'm first looking for any, as the court sees in the motion, we were made aware of this on Friday at 3:30. we've been reaching out to experts, we've been, Google searching really has been our, how we've been finding out any information on it. So I very much need to redepose Dr. Burston as to this issue to find out what it is and to be able to meaningfully cross him. And I'm asking, in addition to the redepose, that before I redepose him, that I be provided with any authority for this idea of counterclaimant violence that the state is using or relying on or anything, because we've never heard of it before.
Do you have any objection to them redeposing him?
Well, yes, Judge. This catatonic violence is not a diagnosis. It's not a disorder. It's a descriptive term. I'm not even sure that I should have had to provide it to the defense, but in abundance of caution I did. I've spoken to Dr. Burston. If they have a problem with that word, that phrase, we can just proceed without that phrase and go and testify. He was just using that phrase to just be a descriptive phrase of the testimony that he'd already given in deposition and he planned to give. So if they're upset about the word, don't have a problem with it. We don't have to go forward with the word. But the descriptions of how the defendant got to where he was on the bridge and the violence that was welling up within him, that's all been discussed in the deposition, so there's no reason to redepose.
Okay, so you're willing to go without this term?
Yes, Dr. Burston said he would be willing to do that.
And there's no new information other than this descriptive term?
Correct.
I don't know how, I don't know how I know that that's true. When you do again, Google searches to try to find out what this is, it is something that is referred to in sexual murders. It has to do with serial killers. It has to do with apparently some overwhelming emotional drive that someone has that overcomes them such that they, I'm not sure if it's the idea that they lose all impulse control, if it's that, I don't know what it is. And
Well, he's not going to talk about it.
Well, apparently he is.
No, he's not.
Well, so I think this is, I'm not trying to open the door to this PCLR and that discussion again right at this moment.
We're not having that discussion again.
But, so.
He's not going to use this word. And there's nothing new except this word, and he's not going to use it.
Well, this idea that a person, if I'm gathering my information correctly from Google, that.
Hold on. Let's not borrow a problem when we don't have one. It's my understanding he's not going to use this word. Is there anything different, Mr. Ellis, about the testimony that he is going to give than we know about? Dr. Burston?
Judge, he's here. If you want to ask him directly, it might be a better idea.
Yeah, average.
Have you been sworn in yet? All right, please clerk, raise your right hand, or take the oath.
You do solemnly swear to affirm, tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, sir, have a seat in the red chair, speaking loud and clear voice for the court. Make sure you move up close.
Good morning, Dr. Burston.
Good morning.
Has anything changed about your opinion in the last, since you testified in court on that PCLR?
Well, this is different than the PCLR. This has to do with a pattern of violence that I outlined in my report and discussed in my deposition, and I ascribed a name to it when I was talking to Mr. Ellis and we were preparing for my direct. It's, like I said, we can delete the name, and it's no different than what I've talked about. And if I'd be happy to explain that a little bit in more detail if it pleases everyone here.
Questions?
I have many.
Okay.
Many questions. Dr. Burston, could you please point to, in your written evaluation, where you speak about the 5-step cycle that this pattern of violence talks about?
The what?
The 5-step cycle of cytophymic violence?
Well, one step is that there is a conflict between intimates. In this case, if I want to make it specific to this case, that would be Michelle Kerr and Mr. Jonchuck. The conflict can be of short duration or it can be months in duration. Over that time period, the conflict for the individual who eventually commits a murder, the conflict grows It festers, it percolates, it becomes more intolerable for the individual. The individual, in most cases, will experience some violent ideation, which I believe was present here, and I talked about that. And it ultimately culminates in a violent act, a murder. And after the completion of the murder, there's a sense of calm and relief. I can liken it to a teapot on a hot stove, beginning to simmer, boil, and eventually whistle quite loud. That's all it is.
Okay, so my question was, could you tell me where in your report you refer to this 5-step cycle of catathymic violence?
Well, I don't know about 5 steps, but the first step is a conflict between intimates. I talked about all these things. The second step is that it starts to fester and percolate. The third step is that there's violent rumination. The fourth step is there's a violent act. And the fifth step is that there's that sense of calm after the explosion. That is what catathymic violence boils down to. I discussed that scenario in my report, in my deposition. I talked about it, that this was something that was boiling, that was long-standing. Not using the term isn't going to change anything that I have to say.
Okay, so would you agree with me that you did not refer to a 5-step cycle of cytothymic violence in your report?
Well, I didn't use the word catathymic violence. Correct.
Catathymic, sorry.
Absolutely.
Trying to learn the word.
Yeah, absolutely I did not.
What about in your deposition?
Absolutely did not use the word.
Okay. So apparently when this crisis reaches a maximum intensity, the individual feels that only through action, which is lashing out and destroying his or her perceived persecutors, can a peace of mind ever be restored? Can you tell me where in your report you said that?
Well, I didn't say it in those terms, but I did talk very clearly in my report, and it's probably in one of the last pages, that this murder was a culmination of a variety of conflicts for Mr. Jonchuck, conflicts with his mother, conflicts involving jealousy with his mother, conflicts involving chronic anger with his mother, that he was acting out against everyone in his life, which included his father, certainly Michelle Kerr. And there were other stressors simultaneous that increased that tension and that explosion, and that led to the murder.
Can you tell me where in your deposition you say that Mr. Jonchuck's peace of mind could only be restored by committing the murder?
No, I didn't use those terms. It doesn't have to be A, explicit, B, explicit. It's a general pattern of violence. There's several patterns of violence. You know, if someone's at a bar and they're talking and person A says something bad about person B's mother and person B slugs him, that is what's called affective or emotional violence. There's a predatory violence. There's catathymic violence. These are nothing more than patterns of behavior, and I described a catathymic buildup in this case. Clearly, that's my conceptualization of what transpired, what occurred. Again, the word is immaterial.
Can you point to where you indicate in your report that John's main focus was to destroy the perceived source of his suffering?
Well, I didn't use those terms, but I did talk about, and I might have not used the word revenge, but I talked about him lashing out and getting back at everyone in his life who he felt was against him. I mean, I can look at my report and find the paragraph.
Can you show us where in your report or in your deposition you refer to the 3 types of catathymic crisis, those being the delusional, chronic, and acute?
Well, I certainly talked about the psychotic hypothesis concerning the murder, and I talked about the non-psychotic hypothesis. Chronic and acute means, or those are just time frames. So certainly I addressed the fact that catathymic violence can occur in psychotic mental states. And I didn't use that phrase exactly, but I talked about that in great detail in my report. Because I looked at both sides of this case, both how Mr. Jonchuck's psychotic symptoms might have affected what he did, and how other symptoms, other problems he's had throughout his life might have affected how he did. Catathymic violence can occur in two major mental states, one being psychosis, the other being a borderline personality disorder or borderline personality disorganization. I clearly made those differentiations. There's no attempt on my part to pull the wool over anyone's eyes in the last minute. Again, we can delete the term. You know, it's no big deal.
Well, I'm curious if you could do you have a copy of your report?
Of course.
Okay. Could you show me where in your report you referred to one of the necessary phases of catathymic violence as being a period of brooding over the grievance?
Okay, this is on, do you want me to read this to you?
I want to know where the words brooding over a grievance are found.
Well, I don't believe that you have to use a specific word to get across a specific point. Okay, there's no word brooding over a grievance, but certainly I discuss, as it applies to Mr. Jonchuck, that he was brooding over multiple grievances.
Do you ever in your report talk about, and again, I'm just learning about this as you're testifying, that catathymic violence can be as a result of borderline personality disorder or psychosis?
Well, I do talk about the differentiation between the psychotic symptoms that I believe Mr. Jonchuck definitely had and personality disordered symptoms, which I describe in my report, which also includes borderline personality disorder. I didn't write it like a textbook. I didn't lift it from a textbook. This is an accumulation of my knowledge as a forensic psychologist, and I applied it to this case based on my accurate understanding of the phenomena, the theory, and the facts of this case. So if you're going to ask me to describe things word from a textbook, I didn't copy from a textbook. This is my understanding of clinical phenomena.
One that was not ever mentioned in your report.
By name,
Nor
definitely,
ever
definitely,
in deposition.
most definitely. We're on the same page. There's no problems there.
Is catathymic violence something that you made up?
No.
Okay.
You Googled it, right?
Well, yes.
Okay, so I didn't make it up.
Okay, so
Okay.
you knew about it before you wrote your report in this case?
Well, yes, obviously, I thought that this was applicable in terms of the pattern. Yes, the pattern of violence here.
You know, I'm only on my first article, asking him questions about it. I would like to not have to do my deposition on this issue in
Well,
open
hold on
court.
a minute, maybe. Did you mention the 5-step cycle in your report?
Well, I mentioned 5 steps as I
But not
talked
the
about.
cycle.
I didn't use the word cycle.
Okay.
Or 5-step.
Could you can I
Sorry.
talk, Ms. McNeil, without being interrupted? Thank you. So you didn't talk about a 5-step guide?
No, I didn't.
Cycle, okay.
Because I don't think that there's a specific guide. I think
Good,
there's a
so-
general pattern which I could, again, I hate to be repetitive, Your Honor, but I'm
Good.
trying to avoid problems here. We can just can the term.
I'm a pretty good learner.
Okay.
Can you eliminate 5-step cycle from your testimony?
I didn't never use the term. I can talk about the process that one goes through in, that I believe Mr. Jonchuck went through in ending up committing the murder of his daughter without ever referring to anything more than how I perceived his emotional state to escalate.
Okay. And the other new term, which somewhat bothers me, is revenge. I'm inclined to let them redepose you as to using the term revenge.
Well, they can.
Is that anywhere, or is that new? You said it was new.
Well, it's not, I'm not using it in the context of catathymic violence. I'm talking about his motivations.
Is there any word that comes close to revenge?
In my report?
Yes. Which would be synonymous with the word revenge.
Let me look for a moment, please.
Okay.
Well, I talk about, can I read a little?
Yeah.
Okay, this is towards the end. There's evidence that at the time of Phoebe's murder, Mr. Jonchuck was experiencing chronic as well as acute anger towards his mother. He was very jealous of his mother's relationship with Phoebe. That relationship excited lifelong feelings of maternal rejection, abandonment for Mr. Jonchuck. He was enraged with Michelle Kerr. The existence of both of these women served to threaten his relationship with his daughter, thus generating marked perceptions of abandonment. So I'm talking about this being an act of aggression towards his family and other people, okay? That's my conceptualization of it. I don't have to use the word revenge.
I know. Okay, but if somebody redeposed you as to that new term, that would be your response?
Absolutely.
Okay.
Oh, and actually, Your Honor, just to be sure, right after that it says, it is this psychologist's opinion that while the defendant may have indeed loved Phoebe, throwing her off the bridge constituted the most powerful way to retaliate against the emotional threats and injuries that Mr. Jonchuck was experiencing at that time. So, I mean, this is all in my report. Did I use the word revenge? Would you rather me not, like some other words? No, I'm saying I'm fine.
But the only problem
tell me what to do.
is psychopath and maligning his character as opposed to describing certain characteristics that my understanding could be the result either of a psychosis or could be a result of anti-personality disorder. Am I correct?
Antisocial, yes.
Sorry, antisocial.
Yeah.
Is that correct?
Correct.
And I think that's basically what this case is all about. Is it part of his mental illness, or is it separate and apart as to motivation and therefore not NGRI? Am I incorrect in that analysis? Isn't that where basically the difference of opinion lies? Everybody agrees that psychosis can display itself in these psychopathy features, correct?
No.
No, okay, I'm wrong. Explain that to me.
Well, psychosis is what the three doctors who testified last
Right.
week were talking about, hearing voices, having delusions, things of that nature. And if you read my report or...
I didn't read your
No,
report.
okay,
Nobody
well,
gave it to me.
Oh,
I
okay.
can't read
Well,
things.
I didn't know that.
No.
Excuse me. Certainly, I gave Mr. Jonchuck a diagnosis, and I'll testify about this, of course, of bipolar disorder 1 with mood incongruent psychotic features, which was one of the defense doctor's diagnoses. And I'm going to talk about the fact that there were psychotic features present. However, there's two sides to the coin, and there's also severe personality disorder. And some of those psychopathic features constitute his personality disorder, as well as borderline personality features, antisocial personality features. And so you're right, that's what it comes down to is, what was driving him, besides the PT Cruiser, no puns intended, at the time he was on the bridge. And so certainly I'm going to talk about personality disorder, but to answer your question, psychosis is kind of one pathway to the bridge, what happened on the bridge, and personality disorder is another.
But my question is, psychosis could also display that list. A person in a psychotic state or a person who suffers chronic psychosis could also have all of those issues.
Yes, there are
That was my
there are
question.
mentally ill individuals who have strong psychopathic traits.
That was my question.
Obviously, of
Okay.
course.
Well, it's not obvious
Yeah,
to me, I'm
yeah.
just learning.
Okay, I apologize.
So somebody could be NGRI or not be NGRI, kind of depending on the interplay between their antisocial personality disorder and their other psychotic disorders.
Well, that's a possibility. Every case is, every case is a
Okay.
unique case. You can have psychopathy and you can be mentally ill, or you can have psychopathy and not be mentally ill. So you can have them both together, but it always comes down to, what was going on at the time of the offense,
Understood,
right?
understood. Okay, you tell me why you need to redepose that.
Well, because I don't know what this characterization or the idea behind it, I don't know how it
Behind
plays
what?
into our case.
Well, he's not going to testify about it. He's not going to testify about a 5-step cycle. He's not going to testify about catatonic violence. And he's explained the term revenge. I mean, I think it's consistent. It might be a little bit a different word, and you can certainly cross-examine him that he just came up with that word this morning or whenever. But I don't see why you need to redepose him. I don't see anything new unless you want to raise, and I don't think you do, the catatonic violence.
Well, I don't know, because I have never heard the term before Friday to be able to have deposed him on it,
Okay,
to
why
be
in
able
the
to
world
talk.
would any defense lawyer want to make that part of their cross-examination on this case? And isn't it true you decided 2 days ago, after listening to the rest of the testimony, that he's even worse than you thought? And I know that's not the reality, but that's what it's going to sound like.
Well, which is why I need to know more about it in order to make sure that my cross-examination is effective. And how do I know? We've just talked for 15 minutes. I mean, we've touched on just a few, very few of the things that are associated with this. I would like to ask about how this murder of Phoebe Jonchuck is related to an affective catharsis. I don't know the answer to that, so I can't ask that question yet.
that word.
Right.
But I did talk about, as I read, that there was a build-up and build-up and build-up to the point where he committed a murder, and due to, as I said, all of his life anger towards his mother, long-term and acute or immediate anger towards Michelle Kerr. There were some other issues that I described in my report as well, but I described this as the custody conflict, which, if you want to get back, I hate to say the word catatonic violence, but
You're not going to be able to.
and I'm not going to, no,
Okay.
but just for us to understand, I discussed in my report and my deposition that there was this ongoing conflict between Michelle and John, and it was around custody issues. And that I think that, as well as some other things, again, his mother's relationship and his relationship with his father, these things grew and festered. And I do believe that there was some violent ideation. And I said in my report that he told his mother, I'm going to fuck up your life. He told Genevieve Torres, nothing's going to matter after tomorrow. He was fixated on bridges, which now retrospectively we see as the crime scene. So obviously he had these things going on, and they're out there. I mean, they've been out there, they're in the records, they've been talked about by other experts, they were considered in my report and discussed in my report. And I'm talking about how this all escalates and culminates in the murder. I don't think that my testimony, that's why, use whatever word, I'm going to talk about a pattern that grew, festered, and resulted here in what we're all here for, the murder.
Okay, I don't see the difference.
Okay.
And I don't buy it that you have to depose him to find out what catatonic violence means. I think he's already explained it, but I can't imagine that you'd be cross-examining about that. I just don't understand why you have to redepose him.
May I
Yeah.
ask the next question that I would ask is, how is the offense in this case fueled by an underlying sexual conflict in which the victim is perceived as a threat to ego? I don't know what to do with that.
Catatonic violence is a pattern of violence. It can be applicable to sexual murder. It doesn't have to be applicable to sexual murder. It is not a term only used in sexual murder. It certainly is applicable to that type of violence. So it's nothing that I would talk about. It's nothing that's relevant here.
Well, it'd be a great gift to the defense if you started testifying about it. They'd have a heyday with you.
Sure.
And I believe that the research would show that catathymic violence is a possible defense in the case, Your Honor, and that failure to raise it could be considered ineffective assistance of counsel. So
You're seriously telling me you are want to raise catathymic violence as a defense?
I don't know that I do, but until I get to explore this concept, I don't know how to go about cross-examining.
I don't think that's true. I'm not going to allow you to redepose him, period. I don't see anything different, and I can't imagine under what reasonable theory you would start talking to the jury about catathymic violence as a defense. Okay, are we ready to start the trial?
Judge, maybe add one more thing.
Sure.
The court has previously indicated you have not read Dr. Burston's report.
Nobody gave it to me. I can't
Correct.
read
Well, and we're all getting this information now. And so it's not in his report. We're not able to formulate cross-examination. We don't know which questions we should ask and which questions we shouldn't ask. If we don't know what answers that's going to elicit. We reached out to experts over the weekend, and none of them had heard of this.
He's not going to answer catathymic violence. The words will not come out of his mouth. I don't care what question you ask him.
Right.
Fair enough?
I never planned to.
But Judge, you can, I mean, the state did a motion to redepose our experts. The court actually said, how will we know, how do they know that they're not prejudiced, that it hasn't affected their opinion without redeposing them? We are in this exact same...
Are you talking about the other issue?
I'm talking about when the state asked to redepose our experts versed on the emails. And the court said, well, how do we know?
That's different.
No, the court said, how do we know if it's changed their opinions if you don't get to ask the questions?
Yeah,
what might be a change to you may not be a change to them. So Dr. Burston, of course, he believes that everything he is saying is consistent. I imagine so. However, it's not his job to formulate his cross-examination and to find the actual places where it is inconsistent. And for us to just have to wait and find out in front of the jury the answers, we're never supposed to ask a question we don't know the answer to. And the court is saying, well, of course you're not going to want to say the word catathymic violence, and so that's the end-all be-all. That is not the end-all be-all. We obviously need to know what questions are going to lead to...
Give me an example of what question you're afraid to ask him in front of the jury.
That's the problem. We can't formulate questions about it to see how it is different from what he has previously told us without taking the deposition to do that.
He says that none of his testimony is any different.
He says that. Have you ever had a witness sit on the stand and be like, hey, I'm telling you one thing, but guess what? Everything is so different. That's what cross-examination is for.
If it's a problem, then I'll stop the trial and you can redepose him. I'm not going to take a break to redepose him at this moment. At some point there'll be a lunch break. If you want to redepose him, then fine. But I'm not going to keep the jury waiting. I don't think anything is materially different. If I'm wrong...
How could you say that without having known what his previous opinions are?
The court told me what they were. Ms. Manuel, I'm not going to argue with you. We're going to start the trial. Do you have your next witness ready?
Yes, you have.
Okay.
One question on Mr. Burston's on the stand.
Yes.
You had said something about his criminal background. You wanted that proffered.
Well,
you want it proffered now?
Is he your next witness?
Yes.
Okay.
Well, no, actually,
we got Kirsten to get off the stand, and then he's our next witness.
All right. This is my issue, okay? And you can educate me if I'm wrong. I haven't read your report. I haven't read Dr. Lazaro's report. I think it is extremely prejudicial to refer to Mr. Jonchuck as a psychopath, and I don't know that it means anything.
Oh, well, we've already discussed
I
this.
understand that. So you're not planning on saying he's a psychopath?
No.
I hope not.
No, I don't think I ever said it in my report.
Well, whether you did or not, hey.
I said psychopathic.
One person talks at a time, okay? I put up with some of it. but I'm not going to continue. If you want to be heard, you can be heard. I don't need to hear an outburst from the defense team. Okay.
So just
And it doesn't matter. I don't care what he said in his depo.
Okay.
He's not going to say it on the stand unless you cross-examine him about it. Okay.
just to address
Okay.
the outburst
Okay.
there, the issue, if I'm not mistaken, I never used the word psychopath.
It doesn't
Did I
matter.
talk about psychopathic features? Did I talk about psychopathy? Yes, that's in my report.
Can you use the word psychopathy instead of psychopathic?
I don't know if it's correct English. Okay, so we're talking about psychopathy features or psychopathic features.
But they're interchangeable, right?
Absolutely. It's
Okay.
just the same thing. It's the same thing. And
I understand that,
This
but-
is semantic, and I think it's my personal, I'm not going to say professional because it's semantic, my personal opinion, psychopathic features sounds more gentle than psychopathic, I think, but but they're the same thing. They're interchangeable. And I understand, I'm completely, no psychopathic. I
And then
don't
another
believe
thing-
that was in my report.
Unless you convince me that I'm wrong, is basically name calling. Like, Mr. Jonchuck is just a callous, impulsive, I forgot some of those other, doesn't regard people's welfare, all that large checklist.
Mhm.
I am very concerned about that.
Mhm.
Because I don't know, I understand that it supports your diagnosis of antisocial personality disorder. But I also think there's a danger in somebody basically name calling. And the PCLR, I think I made the right ruling, and I was thinking about it last night, and there's even more reasons I think I made the right ruling, but I don't want to push it over the edge.
Well, I think a lot of this individual's behavior was driven by certain traits or characteristics that are consistent with psychopathy, okay, or
Okay.
psychopathic features. So I'm going to talk about, or I'm planning to.
I
Please
understand
don't
that,
misunderstand.
but it's different to call it a feature as opposed to he is.
I understand,
Okay.
but he, for example, if I talk about, throughout his life that there's been impulsivity or I talk to people who talked about him as being someone who lies constantly. I mean, you can't pick your clients. I can't pick the person I evaluated. I mean, I don't know what to say.
Okay, I know that.
But I'm not interested in shoving someone's face in the dirt. I'm interested in the truth and saying it as politely as I can and as
Okay.
professionally as I can.
Okay.
But that's my opinions are my opinions here.
I understand that.
Yeah,
I'm not trying to
yeah.
get in the middle of those.
Yeah.
I'm just trying to make sure it doesn't go over the edge. And my understanding is you did the PCLR. It's been fry tested for sexual recidivism. It hasn't been fry tested for this. There's kind of nothing either way about it. And you decided to use it as a tool. And I'm guessing that decision came from the fact that the traits that it measures are traits that are used to predict who's going to be a recidivist for sexual violence
Well-
and for repeat offenders.
But I'm
And
not
you used
using it
for
in
some-
that way.
I know,
Okay,
I know
okay,
that, but,
okay.
no, I know that.
Okay.
But you're using the same list, the same test for a different thing.
To get a better understanding of the defendant's personality, and personality is who we all are.
I got
So
it.
that's
Okay.
it. That's
So
it.
that's my only concern,
Yeah.
and I'm not trying, does that get in the middle of your presentation,
What?
what I just talked about?
Well, I'm going to use terms. I'm not interested in mudslinging,
Okay,
but I'm interested in describing traits or characteristics that, like the other doctors, and I don't disagree with a lot of what they said, hearing voices, hearing the Bible knock, Phoebe chanting, those are things that they said. I'm going to be talking about relationships that are interactions that have been callous, that have been disregarding of the people around him, that has reflected impulsivity. I mean, because those are the variables that I think are more central here and that led up to this whole thing, as opposed to his psychotic symptoms, which I believe were present.
okay. And some of the, that Mr. Boland said, some of this list on the psychopathy features, how many times he's been arrested, criminal activity, you are not objecting to that not being mentioned, correct? I don't think that's a wise idea.
Judge, I would just say first, before Mr. L shows that, I think it depends on what Dr. Burston can say as to what he needs to be able to testify to make that antisocial personality diagnosis. If he says he has to...
I'll let you be heard.
If he says he has to address those issues to make that diagnosis, then I think it does make a difference. So maybe that's...
Well, maybe look at this list, I don't know.
Well, I think that the diagnostic list for antisocial personality disorder might be
More appropriate?
not more appropriate, but of equal
There is a
importance.
diagnostic list.
Do not interrupt. It's not professional to stand up and hold a book as he's testifying and tell him. It's not.
I was
Sit down.
offering to bring it to you.
Sit down. Okay. Criminal versatility. Yeah, I don't like that. What does that mean?
Well, it means that part of Your Honor, part of the diagnosis of antisocial personality disorder is that someone has engaged in behaviors with some consistency that are grounds for arrest. So what your antisocial personality disorder is identifying the criminally oriented personality. So obviously, one of the items on the psychopathy checklist is criminal versatility.
Okay. If I had one of these tests, I might be a psychopath.
Well, we save that
I'm
for another day.
serious.
We'll save that for another day.
Okay. All right. I don't think from 17 to 20, the short, I mean, I think some of these things are ridiculous. It's not my opinion, but you know, you get divorced, you sleep with a lot of people. Okay, so what? You're promiscuous? All right. It's just my personal opinion.
Well, Your Honor, I'm not going to comment.
All right, but I don't think 18 through 20 should be testified to. Juvenile delinquency, revocation of conditional release, and criminal versatility.
Well, I mean,
Okay.
you're the decision.
I know, but I'm asking you. They
Well,
have
no.
asterisks off.
Well, they have asterisks after them because they're based on if you get like juvenile delinquency, if you get picked up for bubble gum stealing at 7-Eleven, you get a 1, petty theft. If you have a grand theft auto when you're a juvenile, you get a 2. It's a serious offense. So that's the asterisk. Revocation of conditional release, if you are violated and you're put back on community control, you'll get a 1. If you violate your conditional release, you go back to prison, you get a 2. Criminal versatility, if you have 4 charges or convictions, you get a 1. If you have 6 or more, you get a 2.
Does Mr. Jonchuck have 4 or 6?
He has. I'm being nice. He has 4.
4
Yeah.
of misdemeanors?
Doesn't.
I understand it doesn't matter.
Well, one of them's
Scale.
murder. One of them's murder.
Tell them what.
What?
Why don't you tell her what
What are
the
you
ones
talking
are?
about? Criminal versatility?
Yeah.
Yeah. Okay. Mr. Jonchuck has battery, domestic. It's different types of offenses. He has battery, domestic violence. That's 1. Okay. He was charged. It's charges or convictions, not convictions. He has a reckless driving. That's a driving offense. That's 2. He has a violation of probation. 3 is murder. Now, he was arrested for aggravated battery on a law enforcement officer and aggravated fleeing and eluding. Wait a second.
I didn't say anything.
Okay, well, you made an expression. So I didn't count those, even though they are on his NCIC. I didn't count them because I know that they were not fully, formally charged. I know the whole story about it happening in Manatee County, and they want to deal with it. So I gave him a 1, but those are this is part of who this individual is. He does have a history of violence. He does have a history of criminal offending. He does have a history of impulsivity. I don't know, as a psychologist, how you can't consider those things when you're assessing someone's mental state at the time of an offense, because it's just not as simple as this guy he's psychotic, so therefore he had to be nuts at the time he committed the offense. I mean, it just doesn't work that way.
Does Mr. Jonchuck got a 1 after revocation of conditional release? What did he do for that?
What did he do? He violated probation twice when he was in the past.
Do you consider that conditional release?
It's any violation, yeah.
Juvenile delinquency, he's got a 2. What's that based on?
Grand theft auto, 16 or 17.
Can I add one thing, Your Honor?
Yeah.
Okay. I just wanted to point out that in order for Dr. Burston to, and he can explain this, in order to make his diagnosis of antisocial personality disorder, he has to find that the defendant had a conduct disorder when he was a child.
Well, at least an element of conduct disorder.
So that is is why the juvenile delinquency is relevant to the diagnosis. And he can explain that more, but I want to make sure the court knew that.
Well, and not just on that charge, but he had a lot of behavioral problems as.
Oh, I understand.
Yeah, so those are all, yeah, but that's
Okay.
all part of the
All right,
diagnosis.
you can be heard.
Thank you.
You're welcome.
Yeah, and first off, as to the probation violation, there's one violation of probation based on this offense. So we can't even effectively cross-examine. With what Dr. Burston just testified to, we would actually have him scored below 30, which takes it off of the psychopathy checklist, but we can't effectively cross-examine that without getting into these things.
Okay.
Dr. Burston just testified to this is part of who this individual is. He also testified that he was needing to testify about his personality, who we all are. 90.404, character evidence when admissible. It is admissible by the prosecution to rebut a specific trait or the trait of peacefulness by the victim if offered in a homicide case to rebut that the victim was the aggressor. They go on to give situations in which other crimes, wrongs, or acts are admissible. There is nowhere at all in the evidence code that once you raise an insanity defense that your personality and character then becomes slaughtered. You still have to follow the same rules of evidence. If he is unable to provide testimony following the rules of evidence that are laid out in the courtroom, then the court should be excluding that testimony because the rules trump. That's what says what evidence comes in and what evidence comes out. There are very limited situations in which somebody's personality are admissible. And it does not say that because you raise an insanity defense. It is when you elicit specific evidence about a specific character trait, they can then rebut that specific character trait. Also, the only conviction that Mr. Jonchuck has on his record is a misdemeanor reckless driving. He was on probation for misdemeanor reckless driving. He has no prior withholds. He's never pled guilty to any other crimes. He has no prior withholds of adjudication. He has no criminal convictions for any crimes involving dishonesty. He has no criminal convictions for any felonies. And so it is certainly misleading to suggest he has a history.
Okay.
The DSM, can I continue this? The DSM gives criteria for antisocial personality disorder. I think there's some confusion. This psychopathy checklist is a checklist, not in the DSM. This is a checklist developed by Dr. Robert Hare to try to rate the psychopathic traits. It is not the equivalent of antisocial personality disorder. Dr. Burston can 100% give his diagnosis of antisocial personality disorder and follow the criteria that the DSM has outlined. It says the diagnostic criteria are pervasive pattern of disregard for and violation of the rights of others occurring since age 15 as indicated by 3 or more of the following. Failure to conform to norms with respect to lawful behaviors as indicated by repeatedly performing acts that are grounds for arrest. 2, deceitfulness as indicated by repeated lying, use of aliases, or conning others for personal profit or pleasure. 3, impulsivity or failure to plan ahead. 4, irritability and aggressiveness as indicated by repeated physical fights or assaults. 5, reckless disregard for safety or self of others. 6, consistent irresponsibility as indicated by repeated failure to sustain consistent work behavior or honor financial obligations. 7, lack of remorse as indicated by being indifferent to or rationalizing having hurt, mistreated, or stolen from another. Then B, the individual is at least 18 years of age. C, there is evidence of conduct disorder with onset before age 15. And D, the occurrence of antisocial behavior is not exclusively during the course of schizophrenia or bipolar disorder. And so there are diagnostic criteria. Him going through a psychopathy checklist in which the only way to appropriately cross-examine him is for them to get into his character. They have not, there is nothing that allows character or personality traits. If it was just because the defense files a notice of insanity and it's a free-for-all, it would have found its way somewhere in the book. They lay out all kinds of exceptions. And certainly if that was one that the legislature intended or the Supreme Court intended us to have, they would have indicated so, that once you raise insanity, their character becomes an issue. And they have specifically not laid that out, although they've authorized many specific exceptions, and when it is admissible, that is not one of them. And so for...
All right, I'm sorry, go ahead, I don't mean to interrupt, I was going to say something.
No, that's all.
Okay. It would seem that this list is about identical with what you've just described as antisocial personality disorder.
Right, I'm not agreeing that antisocial personality disorder comes in. I'm just saying the psychopathy checklist adds nothing at all because there is diagnostic criteria.
So your main objection is it being referred to as like the psychopathy checklist.
No, my main objection is when it is characterized as this is part of who the individual is. This is his personality, who he is. That's someone who lies constantly. When you start introducing improper character evidence, if we had elicited testimony that he's an honest guy, then 100% it would be admissible for them to say, oh, well, he had a history of deceitfulness or something to that effect. But we did not do that because that would be improper.
Okay.
Judge, if I may, Dr. Mathis did talk about the defendant's violation of probation being transported back to Hillsborough when the defendant asked for that. So that his criminal record has been brought up by Dr. Mathis.
Before we get into any other argument, if the only violation he has on the reckless driving is the murder, I'm not going to allow Dr. Burston to testify about 19, revocation of conditional release. And if he doesn't have, he's got a withholds on some misdemeanors, is that what he's got?
No. The only thing ever that he's ever pled guilty his entire life is this reckless driving that he's on probation
What about the
for.
grand theft auto? That doesn't.
No, I don't know. That's what we did the motion to compel, to figure out where that comes from. Mr. Jonchuck made a statement that he was with a friend who stole a car, and then that person burglarized his house when he went to court for it. That's why I did the motion to compel, to see if there was any information or anything to support
Does he
that.
have a conviction for that?
I believe that was as a juvenile. I didn't see that on his rap sheet.
Okay,
Dr. Burston has information about it.
Delinquency.
Well, Judge, part of the problem here is we're talking about criminal versatility in legal sense. You have to think of it as in the psychological sense. How the psychological people created the test and how those experts use those terms don't have to be the same as we use them. If the arrest is for them for this purpose, then that's how it should be. We can't impose legal understandings upon the psychological understandings that they created the test for.
But he just told me that too was because of grand theft auto conviction when he was a juvenile, and apparently it may not exist.
Well, Your Honor, what they talk about is scoring the psychopathy checklist for those that you can certainly use an individual's self-report. Mr. Jonchuck told me it, and his uncle told me it, and it's in his uncle's depot. So there's more than adequate, as this test has been blessed as being reliable, valid, et cetera, I'm not deviating from the normal scoring criteria in any way. So while I understand your concerns from your perspective, this is the way the test is, this is the way it's used by mental health professionals, and so I can't start saying, well, I'm going to erase when it's a 1 because
Can I see the antisocial personality?
it's not appreciated in court.
No, I just want to look at it because it's a good list. Thank you. Because if that's not on here, there is evidence of conduct disorder with onset before age 15. Where would the grand theft that he reported fit in with this, if you had to fit it in with this?
A pervasive pattern of disregard for and violation of rights of others occurring since age 15. So
Okay.
That's part of
That
that.
would be a self-report.
That'd be a self-report and the report of others.
Okay, and the revocation of conditional release, that would just be your conclusion as to the reckless driving, probation, and the murder arrest?
Well, they're both violations, yes.
And the criminal versatility, okay. I don't think it is probative of much to have him testify as to 19. Revocation of conditional release. Because that really hasn't happened yet, I don't think.
Under their theory, Judge, a violation, it doesn't have to be.
I understand, but it just sounds horrible, and considering the facts, it's of little probative value that he was on probation for reckless driving, and he's being charged with murder.
The problem is going to become, judges, and the defense is going to say your scoring doesn't equal because we can't even talk about 19. And they're going to try to say, oh, your scoring is off, you didn't score enough points, and he's going to have to be able to say, yes, I did, and here's why.
Well, I would hope they wouldn't ask that question.
That's exactly what they're planning on asking.
Well, I don't
They've
know
said
what they're
that.
planning on asking.
I would say, Judge, it's already out that the murder arrest served as a violation of his probation.
Yeah, but that's different than seeing it on a list. Okay, so that's, respectfully, Dr. Burston, I think that the probative value of that is almost nil.
I can't argue with you, you're judge.
Yeah, you can. People argue all the time. That's what
well,
court's about.
Okay, well,
I have a
I
different
argue with
theory.
attorneys, but not judges.
Yeah, you should argue with judges.
Okay,
You get
well,
better decisions.
I'm going to just take, I'm going to ride on Mr. Ellis's coattails. There's a big difference between your view of this and the forensic mental health's world
I understand
view
that,
of this.
but it's a balance. You can't have the mental health professional just come in and testify to whatever. There is a gatekeeper involved.
Well, he did.
Especially when you're using a test that has never been used before that anyone knows of with an NGRI.
Okay.
And I'm going to be careful.
Yeah, there's still 2 violations. So,
Well-
I mean, I don't know what.
No on 19. And on 20, that's a no because he's conviction free. And the only thing he has is a reckless driving. And to say that he's, the probative value is minimal and it's really prejudicial to say that. And the juvenile delinquency based on a self-report, no. And I understand your argument, Mr. Ellis, I get it. But there's also the fact that we're using this psychopathy checklist in a way it's never been used before. For
to
NGRI.
Well,
That's part of the problem.
That's
It's
not
to
true.
determine
That's not true.
NGRI.
It's not
That's
to-
part of the problem with that phraseology. That's not what this test was done by this doctor. This doctor took it to look. He went into it, and he'll testify to that he had no idea he was going to ever use this test. But he started seeing the psychopathic traits. Is that the word we're going to be able to use? I want to make sure we're using the word recorded. It's proving of them. Psychopathic traits.
Yeah, I guess.
Okay. The psychopathic traits.
Psychopathy traits.
Psychopathy.
I might slip up. That's not correct English.
Psychopathy traits.
Psychopathy
Do the
traits.
best I can.
Okay.
Okay.
Traits of psychopathy. And then he used this test to see if, in fact, what he was suspecting was indeed true. And then he found out that it was indeed true, and he associated it with the antisocial personality disorder and helped him develop it. So this test wasn't to say whether he's NGI or not. It's when those traits appeared, he had to confirm in his own mind whether they were there or not. So he used this test to confirm it. This, again, no one is saying a test is for NGRI. Their experts said there's no such test. But he used it for that purpose, and then once he found those traits, verified those traits, then he was able to help formulate an opinion. So to say that this was for NGRI is technically not correct.
Okay. All right, the last 3 out, respectfully, I disagree with you, Dr. Burston, and I'm the judge. We're not going to testify about juvenile delinquency, revocation of conditional release, or criminal versatility. All the rest you can do, because to me they're part of the antisocial personality list, basically. And I'm wondering, okay, that's
So-
where I fall.
So he can say he did the test, he went through the test and found whatever the features are.
Absent
And
those
then,
last three, yes.
and then he determined that he fit the pattern.
Pattern of,
Traits of psychopathy.
fit the pattern.
Well, he had traits of psychopathy.
He had traits of
Well,
psychopathy.
he had strong traits of psychopathy, and then I guess what we would want to do, if we're going to use this as a visual aid, is chop off those last three.
Yes.
And not talk about a specific score, because if we say that prototypical psychopathy is a 30 or above, it's not fair to cut off a couple of points and then say he's not psychopathic, or can't use psychopathic, that he's not of psychopathy. So, I mean, that's all fine, but they've got to kind of...
All right,
that's
you want
gonna
to
be
address
used.
that? I understand you don't want it in at all, but I've said the last three are coming out, so what about the score? He really can't testify to that.
I don't disagree. That's why we keep coming back to this being
I know.
just because it has medical relevance or medical significance, that does not equate to legal admissibility. In fact, the rule allowing expert testimony says if it can aid the jury in the evidence before them. And so we don't just say you get to hear a whole bunch of inadmissible stuff because that's how the expert needs to explain his testimony. The expert is allowed to testify if he is able to aid the jury in understanding the evidence that is before them. And so that's where I think we keep getting stuck in this trap by the state trying to backdoor in, well, he needs this to say his opinion. His opinion is not, why did Mr. Jonchuck kill his daughter? His opinion is not, was he not a nice guy? His opinion is only supposed to be whether he believes he meets the legal criteria for NGRI. And they keep saying, this test doesn't show NGRI. It doesn't make it more likely than not that he's insane at the time, which is a relevancy issue. If it doesn't make it more likely than not, we shouldn't even get to the prejudice on how outweighed the prejudicial effect, or how much the prejudice outweighs the relevancy, because their own argument suggests that it's not relevant. That aside, getting to the other issues though, so is the court going to allow him to say that he's callous, impulsive, remorseless, and a liar? Because those are still on the board.
No, that's name calling. Saying that there is a trait of is a lot different than saying that's who he is. You can have a trait and it doesn't mean that's who you are, it just means you exhibit those traits.
Right, but 404 says that that's not allowed unless there's been evidence of a specific trait that we've elicited.
That's not an NGRI case. You show me an NGRI case that says an expert can't testify about antisocial personality disorder and use a reference list, which apparently is in the DSM-5. You show me that.
Okay, well, I have provided the court lots of cases that specifically talk about specific bad acts.
I understand.
Right, and so if Dr. Burston is going to set, and so under those circumstances, and I think actually gave a case too, I think it was a death penalty case that they had tried to get into, that he had actually scored high on the PCLR, and they said some of the things, and they specifically said, but we don't have to go further if it was error because they didn't discuss the traits, what they were.
Okay.
And so here we are discussing the traits. We're at a guilt phase, not even in the penalty phase. And so certainly the courts have suggested, I have not seen anything. In fact, the argument is obviously if it were, they have outlined specific exceptions on when somebody's personality and character traits can come in. And it is not insanity.
Okay,
And
you certainly are not disagreeing with me that these, basically the traits we have left on Dr. Burston's list and these traits are identical. They're just worded in different ways. I've taken off the three that really aren't.
no.
Okay, will you show me one of those that's different from the psychopathy checklist? They're worded different, for sure, but they appear to be the same to me.
Do you let me read you what the definitions are.
Judge, we've already had all of this kind of
I
argument
understand.
before, and the court has ruled twice.
I have, okay.
So I'm asking the court, you know, we keep going over and plowing the same ground over and over, hoping for a different result. And I don't think that's appropriate or fair to the state. We are now in the middle of trial, and the court has ruled twice that we can present this, and now they're
Well,
trying
I've
to...
narrowed it down a bit. I'm open-minded.
Okay. And while we are objecting to that narrowing, we will move forward with it, but our concern obviously is they're gonna start saying, how many points did you get for this, how many points did you get for that?
I'll deal with that if it happens.
All right,
All
we're
right.
gonna open doors, I believe.
Okay, so we are done. I have to have the jury back in, otherwise they're gonna kill us all. Are you gonna be on the stand, or are you gonna?
Yes.
No, Ms. Malcolm's gonna be on the stand.
Oh, okay.
Judge, before we bring the jury, can we address one more issue?
And we'll address it at lunch.
No, I'm
Okay.
asking the court to inquire about the jurors of something, before we get started.
What?
So I think every day we've started in the court has either asked the question, is there anything I need to know about? Or has anybody seen or heard anything that they shouldn't have? I would ask the court to do
I figured that was coming. Yes, I know the answer. Yes, I will.
And specifically, we would ask that because I guess Bay News 9 over the weekend, starting Friday, was killer statement. So I think we need to inquire, even if the jurors perhaps followed the court's rules, stopped and didn't look, if they saw anything in passing or anything to that effect.
Okay, I will. Thank you. All right, let's bring them in, please.
Judge, when we finished last time, she was still on the stand. Can we have her on the stand?
Yeah,
Does
that's,
that
hold
make sense?
on. Deputy Rice, hold on just for a second. We're gonna put Ms. Malcolm back on.
I think it's gonna go rather quickly, Judge. I'm gonna have no more questions. It's my understanding Mr. Williams will have no more questions.
Right.
Oh,
Go ahead and
okay.
line them up.
But we needed to get her
Bring 'em in, yeah.
on and off.
Well, why are we putting her on if you don't have any more questions?
Because the jurors are gonna wonder what,
I'll tell them. Is that okay? Good, all right.
well, we required her to come back, so I just,
Well, that's part of it, but I mean, anybody have an objection to me saying there's no more questions from either side on Ms. Malcolm? Yes? No, you don't have any objection?
No,
Mr.
Judge.
Ellis? Ms. Malcolm, thank you for being very, very cooperative and being here for 2 days, and you were here for a long time Friday.
Yeah.
Thank you very much. You're excused.
Thank you.
She doesn't need to be on standby, right?
No.
Okay. Let's bring them in, please.
All right, Deputy Rice, when you gotta line them up, bring them in.
And I have to tell them why Miss Lloyd is no longer here.
And I guess there was some issue regarding jury payment earlier, because the system was down or something. She said it's back up so they can get their payments at lunchtime.
Okay. What time does the clerk's office close? 4?
It was at 4:30.
4:30, okay.
You're gonna want Dr. Burstyn sworn again.
They're lined up. You wanna bring
Do you want Dr. Burstyn sworn in front of the jury? He was just sworn.
yes.
Okay, yes.
Tim. Quick things, folks, more cell phones are all up.
Yep.
Okay, and those are your notepads, correct? Jury's in the jury box this evening, John.
Thank you. I apologize for the delay. When I say that, I really mean it. There's 3 topics we have to discuss. The clerk's office will be open till 4:30, and apparently the way they pay you is up, so anybody that wants to go down and get payment for their service so far can do it. Ms. Lloyd called up today and informed us she was not coming because she is ill, so she is gone. So we're down 2. Got a lot of people still standing, which is good. The other thing I want to discuss with you, and I've kind of been a little light about it, today we have to be serious about it. Has anyone received any information outside of court on the case? And let me tell you, like I did before, if the answer is yes, you're not in trouble, we just need to know what it is. So please, if anybody's received any information, and I know there's TVs on, and you can go to Wawa's, and I understand that one could be inadvertently exposed to anything, and it would just be the luck of the draw what you were inadvertently exposed to. So if everybody could pause for just a second and make sure that you're giving an honest answer when you say you haven't been exposed to anything about this case, and I'm going to ask each one of you individually. Is it Shaun, is that right?
It is.
Okay. How about you, sir?
I have none.
Ms. Urizari?
No. Are you gonna ask them my number?
Oh. Yes. Sorry. 2247.
No.
1069.
No.
1025.
No.
1179.
I'm scrolling through Facebook.
Okay, whoops, okay. Let's take the rest of the jurors out, please.
I said,
Whoa, wait till they all leave, okay? They haven't been on Facebook.
Oh, the pets.
Oh, yeah, folks. Jury's out of the hearing.
Mr. Miranda, you're not in any trouble. The only way you'd be in trouble is if you didn't tell us something you had seen and we found out later. So tell me everything you saw on Facebook, please.
Just a quick, just scrolling on Facebook, seeing I think it was a news thing, and I scrolled right past it. That was it.
Okay.
That's-
Do you have any questions you want to
It was like a
ask?
half a second.
Okay. Do you have any questions you want to ask Mr. Miranda?
Do you remember whose page was it on? Do you remember, was it like something on?
It was a news thing, so I just went right past it. I mean, I'm just being honest, you know.
Right.
It was literally, it showed like a courtroom, and that was it. Because you can just keep on, you know, going on. I didn't see anything.
Do you remember what news outlet?
I had no idea.
Did you see like a headline or anything at all?
Nope. I just knew it was the picture of the courtroom, so I just kept on going.
When was that?
This morning. I mean, literally, it was like a half a second. So, but you asked me to tell you the truth, so, you know, tell me.
Okay. Any questions? Okay. So we'll just bring in the rest of them, and I'll continue to go down the list, and then we'll have discussions after if we need to, okay? All right. If you can have a seat, we're going to bring in the rest of your colleagues. Thank you.
Deputy Rice, bring them back in.
I remember to wear shoes.
Jury's return to seat.
Thank you. 1203.
Nope.
1193.
Yes.
Okay. If the rest of you would step out, please.
Jury's out of the hearing report, Your Honor.
Okay, 1193, it's very important. You're not going to get in trouble. Just please tell us what you saw or you heard or came in contact with.
Tampa Bay Times. It was the day of the helicopter crash in Hillsborough. The headline underneath it was this trial, and they said something about the last witness for the defense was today or something like that. I don't remember. That's all I saw, and I clicked off of it as fast as I could.
Okay.
Just saw
Anything
that.
else at all?
Not really.
Pardon? Did you say not really?
I think my mom might have said something. I saw you guys got out early. The family all seems to know what it is, but they won't say. So.
Any questions, Ms. Manuel or anybody else? Mr. Seaback. 1193. Sorry.
No, we have no questions.
Anything from the state? Okay. Thank you, sir.
Sit here.
You can stay and then we'll bring everybody else in.
Liberty Rice, go ahead and bring him back in. Jocelyn Rice.
Thank you. 1273. 2248.
No, ma'am.
2023.
No.
2071.
No.
2051.
No, Your Honor.
2042.
No, ma'am.
2262. 2260. Okay. Is there anything we need to discuss or can we proceed? Proceed. Okay, you may call your next, oh, I gotta tell you one more thing. The last witness that was on the stand last week, Miss Malcolm, neither side have any more questions for her. So rather than just leave her here and say no questions, she's been excused. So the testimony you heard from her is the testimony you will have. Okay, you may call your next witness.
Dr. Peter Burston.
Be a moment on the doctor. Introduction. Sir, if you would stand right here, face the clerk, raise your right hand, card take the oath.
You do solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
And now, sir, have a brief seat for a chair. With your loud and clear voice for the court, be sure you move up close to the mic.
Good afternoon, Dr. Burston.
Good afternoon.
Would you state your name and spell it for the record, please?
Sure. My name's Peter, M as in Mark, last name Burston, B-U-R-S-T-E-N.
What is your occupation?
I'm a licensed psychologist in the state of Florida
How long have you been a licensed psychologist?
since January 1985.
What education and training have you had that qualifies you to be a licensed psychologist?
I have a bachelor's degree in psychology. I earned that in 1977 with high honors from the University of Hawaii, and then I went on and earned a PhD in clinical psychology from the University of California at Davis, and that was in 1982.
And what is forensic psychology?
Forensic psychology has to do with providing psychological services to the court system or agencies that are associated with the court, primarily consultation and psychological evaluations.
And have you had training in forensic psychology?
Yes, I have.
Would you go through that for us, please?
Well, after I earned my PhD, I came to Tampa. I had a job at the University of South Florida at the Florida Mental Health Institute, where I worked with severely mentally ill individuals, people with schizophrenia, people with bipolar disorder, severe personality disorders. I was working in what's called a day treatment program, where those types of clients or patients who would otherwise qualify for hospitalization were being treated in the community, where we would work with them throughout the day, and they would go to boarding home types of settings for the most part in the evening. Well, you can imagine, I was there 5 years. Over a 5-year period of time, the clients, unfortunately, would get into trouble in the evenings, on the weekends, and as the treating psychologist and the lead clinician on that unit, I often had to interact with the criminal justice system, and in that manner I became involved with mental health and the law, clinical treatment and the law, and while at the university, I did what many psychologists do who work in institutional settings. I began a part-time practice. Because of that interest in psychology and the law, rather than focusing my practice on like counseling people in the evenings, things of that nature, I began doing psychological evaluations for the court system. So this is, 1985, 1986. And I initially began doing evaluations of competency to stand trial in Hillsborough County, and then I began doing those same types of evaluations in Pinellas, Pasco County.
Were you on court-appointed lists in those counties?
Yes. I've been on the court-appointed list in Hillsborough County since 1985, and in Pinellas and Pasco since, I believe, 1990. I do that type of work in Hernando County and those surrounding counties, Sumter, Citrus. That's just part of what I do. I also, well, let me just go on and say that when I left the university in 1989, I went into my practice on a full-time basis, and I've been in independent practice as a clinical psychologist / forensic psychologist since 1989. My practice involves, as I said, conducting competency evaluations. Over the years, I've conducted many, I can't give you a number, evaluations of mental state during the time period surrounding the offense or sanity. I conduct sentencing evaluations. Involved in the evaluation. I travel around the state of Florida to prisons and evaluate sexually violent predators to provide opinions on whether they're safe for release into the community. And I've been a consultant to child protection agencies since 1985, 1986, where I routinely evaluate parents, children, adolescents who are in that system due to allegations of abuse, neglect, abandonment, things of that nature. Of course, because I evaluate sexual offenders, with the advent of computer sexual offending, I evaluate a number of computer sexual offenders, individuals charged with viewing child pornography, those types of things. Every once in a while, I'll go up to death row and evaluate someone for, death penalty issues. I think my primary focus in my practice over the years has been what's called the assessment of risk or violence, sexual violence. No one can predict what anyone will do in the future, but being able to talk from a psychological perspective about someone's relative potential or risk to engage in certain problematic behaviors is something that's often useful to legal decision makers. So, as I said, I work for myself and by myself. My office is in Tampa. I have a small satellite office in Pinellas Park, and that's the type of work I do.
So you have been qualified as an expert in forensic psychology?
Yes.
In Florida?
Yes.
What different courts?
Well, Monroe County, I don't think I've ever testified down there, but that's the Keys. But from Dade County up to Jacksonville on the East Coast, from the Panhandle over to Tallahassee and some of the major spots on the West Coast, and Polk County, which is in the center of the state. So basically all over Florida.
Can we approach, Judge?
Mm-hmm.
Were you hired to do a forensic evaluation of the defendant, in this case, Jonchuck?
Yes, I was.
Who hired you?
Your office, the state attorney's office in Pinellas County.
Does who hire you make a difference in your professional opinion in a case?
No, of course not.
Okay. How do you normally conduct a forensic evaluation?
Well, generally, I receive records concerning any given case, police reports, if there's mental health, physical health records, depositions, all available information concerning a case, and I review that before I go see the defendant so that I have a good understanding of the case, what's been going on, and as much of an understanding from records of the individual I'm going to meet and evaluate. I then travel to the facility. In this case, it was for Mr. Jonchuck. It was North Florida Evaluation and Treatment Center. I met with him on February 15th and 16th of 2018. and I conduct a face-to-face evaluation. My evaluation with Mr. Jonchuck, as I said, it was over a 2-day period, and I'm just going to check, but I believe I met with him for a total of about 5.5 hours.
Why did you meet with on 2 different days?
Well, there's a lot of information, and I didn't want either myself or Mr. Jonchuck to become fatigued. That was the main reason.
What are collateral witnesses or informants?
Excuse me?
What are collateral witnesses or informants?
Well, collaterals are individuals who an evaluator might choose to meet with face-to-face to get additional information about the defendant.
Did you have police reports and depositions of collateral witnesses in this case?
Yes.
Did you conduct any of these personal interviews of the collateral witnesses?
Yes, I did.
Why'd you do that if you already had that information?
Well, I wanted to know as much as I could about the individual who I'm going to evaluate. For example, I met with his uncle, his maternal uncle. I met with Mr. Jonchuck's father. I met with his mother. I felt that a personal interview with them would allow me to get more information specific to Mr. Jonchuck's early childhood and upbringing and the what we call the psychological or psychodevelopmental years of his life. I conducted a telephone interview with the mother of Phoebe. She spent 6 years with Mr. Jonchuck, and I just wanted to get from her as much information as I could concerning Mr. Jonchuck. I spoke with 3 friends of his, again, just to get more information about the individual I'm going to evaluate. And I found that information to be exceptionally helpful and enriching and expansive in terms of how much more I understood about Mr. Jonchuck, his life history, how he interacted with people over the years. That's why I did it.
Have you worked for both the state and defense in criminal cases?
Absolutely.
Do you know any idea percentage of the time that you work for the state versus percentage of the time you work for the defense?
No, I've been doing this type of work since the mid-1980s. I don't keep statistics on every person I see, every evaluation I do. I'm on court-appointed lists, as I said, so a lot of the work that I do is court-appointed, but that's primarily for competency evaluations. I'm hired routinely by both sides, the state and the defense. And of course, I do some work that, for child protection agencies and some for private attorneys. But in terms of the state and defense balance, I would imagine if I'm looking at all types of cases I do, I would say it's pretty 50-50 or maybe 60-40 in terms of defense attorneys.
Have you worked for the defense attorneys for Mr. Jonchuck?
Yes.
Have you worked for their office?
Yes.
Did you look into the family history of the defendant?
Yes, I did.
Why would you do that?
Well, again, as I said just moments ago, it's very important to understand as much about the individual as possible. And us psychologist types believe that what goes on in one's early family history is very important in terms of, in this case, Mr. Jonchuck's early development, which grows and develops into child and adolescent development and adult development. So understanding his background is the foundation for getting to understand him.
Did he have any siblings?
He had a half-sibling on both sides.
Were his parents married?
Well, his parents separated or divorced when he was 2 years of age.
And did his father remarry?
Yes, I believe Mr. Jonchuck was 5 years of age at that point.
And to whom did he remarry?
Mrs. Jonchuck. I don't remember her first name.
The stepmother would have had the same name as the biological mother?
That's correct, Michelle.
So how are we going to differentiate them when we talk about them?
Mom or stepmom.
Okay. When they separated, who had the defendant at first?
Well, my understanding is that the biological mother had Mr. Jonchuck, and as Mr. Jonchuck told me that one day she took him and dropped him off at his father's house and left with another man.
And did he grow up with his father at that point?
He grew up with his father, and then again, about 3 years later, stepmother came into the home, yes.
Was there times when he spent periods away from his father and with his uncles?
He stayed with his uncles on weekends, you know, on and off. There were times when he spent more weekends with them and less weekends, but they were certainly part of his life during early childhood and mid-childhood. Actually, early adolescence, he actually lived with them for a year or so.
What are bonding issues when we're talking about children?
Well, bonding is part of what we could call early child development. And I guess the term would be attachment and bonding. And attachment and bonding is something that's hardwired into all of us human beings. It has to do with the relationship between a newborn and the newborn's, I could either use the term significant caretaker or mother. I might go back and forth between them. But basically, when a child is born, a newborn, the newborn has no sense of anything but his or her own needs. As within the first year of life, the newborn, again, it's hardwired in, bonds, or there should be an adequate, acceptable bonding with the primary caretaker or the mother. So while a newborn initially doesn't have any sense of anyone but themselves, within the first year of life, as that bonding occurs, the newborn starts to say, hey, I'm not the only act in town. There's this other person or this other object who I'm getting to know. There's a lot of connecting. Obviously, the child has no verbal skills, but on an emotional touch, feel, eye contact level. And the child starts to say, hey, there's another person or another object again. And the child starts to have concern or feelings for how that other object, who they feel bonded to, who takes care of them, thinks and feels. So in terms of the initial steps in bonding, when a child starts having some sense of reciprocity or connection, that's the beginning of what we can call empathy. As the child gets a little bit older, perhaps in the toddler years, the child is getting strong emotional supplies from the primary caregiver, but also other people in the environment. The child starts to develop a sense of, I don't want to make mommy mad. I feel bad if I make mommy mad. I don't want to make mommy mad at me. So the child starts to develop what we might call the beginning of guilt and remorse. So when there's adequate enough bonding, that's sort of the foundation or the start of what we might call a conscience. Guilt, remorse, empathy. On the other end of things, when there's failures in bonding, there's lack of those things. There can be in a more severe failure in early infancy child bonding, there can be essentially without conscience or a lack of conscience. Individuals who have those types of failures, and it's understandable, they have strong feelings of rejection, abandonment, and so they carry into the next stages of life, childhood, adolescence, and adulthood, anger, hurt, depression, again, rejection and abandonment. So mood tends to shift. Anger, depression, depression. These are people as they get older. The impulsive display of anger is very likely. And of course, relationships tend to be unstable. Again, it's these early experiences that identify how people kind of move through life. So, bonding and attachment obviously are very important considerations. And one other aspect of that is that because when there's again developmental failures, lack of bonding, lack of attachment, the individual doesn't really see people because of that. Again, that empathy doesn't develop. They don't see others more for who they are. In a more childlike or infantile manner, they tend to view other people good, bad, right, wrong. So there's really this black and white thinking. And particularly as infants and very young children move into childhood and adolescence, particularly boys, males, these types of problems with mood, anger, impulsivity, what we call deregulation of emotion, they're expressed per violation of rules, getting in trouble, acting out. So you start developing, with bonding and attachment problems, really the core, the foundation of what we call maladaptive personality disorders. And I'm really describing traits or characteristics that reflect both, and I'll talk more about this, I'm sure, borderline and antisocial personality traits or features.
Did you look into the educational history of the defendant?
Yes, I did.
Why would you do that?
Well, again, education is the first kind of big step, you know, whether it's daycare or first grade or kindergarten, the first step out of the family unit. So obviously I wanted to look at that.
And what did you discover when you looked into his educational history?
Well, following up with what I just said, both Mr. Jonchuck's father and Mr. Jonchuck's uncle told me that Mr. Jonchuck had severe problems beginning in the preschool years. Mr. Jonchuck, aside from what I talked about, was also very hyperactive. Now,
what does that mean?
Well, it means attention deficit hyperactivity disorder, which I might refer to as ADHD. That's when a child is just hyperactive, has difficulty sitting still, short attention span, always on the go. I think what I'd like to point out is that you can have the types of problems I just talked about that have to do with bonding and attachment, and you can also have hyperactivity. It's not, I can't fall into thinking black and white, one or the other. They can co-occur, and they often do. So at an early age, in my opinion, Mr. Jonchuck was dealing with a lot of psychological and behavioral liabilities. In terms of his school history, again, right from the earliest daycare times, there were marked behavioral problems. He actually was sent home at one point from daycare, according to his uncle. Mr. Jonchuck had described to me behavioral problems in school. He went through the first year of high school, dropped out during the first year of high school, later earned a GED when he was 18. But he described himself as being a class clown. He said he threw spitballs at the teacher. He engaged in, behavioral acting out at school. He described 7 or 8 in-school suspensions. His uncle talked about one suspension when Mr. Jonchuck was a little bit older for fighting. But generally, the first step out of the family unit in school can be characterized as being reflective of very disruptive behavior, difficulty fitting into the system, interacting with other people.
Did you look into his employment history?
Yes.
Why did you do that?
Well, that's another important aspect of life, how someone functions on in the work world, and so of course I ask questions about that.
And that would also include his financial situation?
Well, that's usually associated with working, yes.
Okay. Did you look into how many jobs he held?
Well, he held a number of jobs for short periods of time, relatively short periods of time. Mr. Jonchuck did report that his longest period of employment consistently at any time was 9 months. He described working, I'm going to have to refer to my notes, that he sold electronics for credit cards. He had different sales positions, including like call centers, telemarketing. There was a period of time where he earned an insurance license for Medicare products through Humana. Mr. Jonchuck told me he was never fired from a job. He told me that he did quit a few jobs without having other jobs lined up.
What does that mean to you, if anything?
Well, that shows some degree of responsibility. In Dr. Arthur's notes, I know there's been discussion of Dr. Arthur, there is indication that Mr. Jonchuck was let go from one job, the Humana job, because he hadn't shown up regularly. So the work history, he described periods of unemployment between 17 and 25 years. And of course, he began to receive Social Security disability funds at around age 22, 23.
Why was he receiving those?
For mental health and back problems and seizures.
Did he receive any funds for Phoebe?
She received Social Security funds, yes, so he did. At some point, he did get her Social Security check. He was what they call the payee.
At the time that he was stopped by the police, he had a Social Security letter in his possession. Are you aware of that?
Yes.
What significance does that letter have to you, and what was in it?
Well, the letter, I've reviewed the letter. It had to do with, it was a request from the Social Security Board for Mr. Jonchuck to explain how he was using Phoebe's funds in her best interests for her welfare, food, housing, things of that nature.
Did he indicate he had received some pre-settlement loans?
Yes, he did. He talked about that.
What is a pre-settlement loan?
Well, Mr. Jonchuck had evidently had a lawsuit going due to a back injury, and I'd never heard of pre-settlement loans before I spoke with Mr. Jonchuck, but he told me about it. Basically, with the assumption that he was going to earn or receive a large settlement, pre-settlement loan, he got a loan on the settlement. And he told me there were two, and I believe for a total of $25,000. This was about 2 years before Phoebe's death.
And did he indicate what he did with the money?
Well, he bought a condo, yes.
Okay. And did it come a time where he defaulted on those loans?
Well, he defaulted on the loans. He defaulted on the condo.
Okay. And what significance should that have?
Well, just like the spotty work history, these are, my interpretation of this is a lack of responsibility, a tendency for someone to more or less just not, again, take responsibility in a more adult-like or socially appropriate manner.
Did he occasionally get financial help from his parents?
He did receive financial help from his parents. He also, his parents primarily took care of Phoebe financially.
And did he indicate that he was not a good steward of the money that he received?
Yes, he admitted to that. Yes, he told me he spent money very impulsively. He indicated that during the last year of Phoebe's life, he had her Social Security and his own, and he used that money just to kind of, he was living with different people to hang out and spent the money on drugs.
Can we approach, Judge?
Yes.
Can I go ahead?
No.
Dr. Burston, are you aware of a situation where the defendant got a scanner and a printer?
Yes.
Could you tell us about that?
My understanding is Mr. Jonchuck was working, selling insurance products for Humana, and he bought a scanner printer and was able to duplicate the checks and then, in turn, cash them.
And did he get in a situation where his mother had to become involved?
Yes, she evidently there was a large debt incurred, and she paid for that debt off.
Was that to keep him out of trouble?
It's my understanding, yes.
Did the defendant take prescribed drugs and illegal drugs in his lifetime?
Yes.
Okay. What did you find out about that drug use?
Well, I asked Mr. Jonchuck about that. All of these things are typical questions, employment history, financial history, drug history.
Objection, non-responsive.
Why would you ask such questions?
Well, again, these are typical questions to get to know a person as broadly and as deeply as I can. That's part of an evaluation, is to understand the individual. So yes, in terms of drugs, I definitely took a substance abuse history, yes.
Okay. And what was that history?
Well, Mr. Jonchuck told me that he began to use alcohol at age 14, and during adolescence, around the same time, 14, 15, he began to use marijuana. And
you said marijuana at 14, 15?
Yeah. Yes,
not at
correct.
12 years of age?
No, not at 12. That's not what he told me. And began to use marijuana and methamphetamine. He told me that during his adolescent years, for me adolescence is up to 20, 19 is a teen, he used marijuana and methamphetamine regularly, like daily. And then he told me that in his 20s he began to use spice. Mr. Jonchuck stated that around age 18, for a year or two, he just drank wine, smoked marijuana, and used spice up until 2012. Then he told me that there had been a period of sobriety, but he also told me that for the year prior to Phoebe's death, again, he was living with other people and using Phoebe's money to buy drugs, and he was using spice. I was also told that he would be home drinking during the day. So I think that the substance abuse had been pretty persistent since early adolescence, at least.
Did you learn when was the last time he would have used drugs that you're aware of?
Well, Mr. Jonchuck told me that he discontinued alcohol use during September of 2014, and then during November of 2014 there was a relapse on spice, marijuana, and methamphetamine. He stated that the methamphetamine use was like 1 week in November. The marijuana use was for a week and a half in November. It was November of 2014. And he reported using spice through mid-December 2014, which would be, about 3 weeks before Phoebe's death.
Okay. Did you look into a psychological history of the defendant?
When you say psychological, you mean his mental health treatment history?
Yes, sir. That's
okay.
That a word for it?
Yes, I certainly did.
And what did you discover?
Well, Mr. Jonchuck told me that he became involved with outpatient mental health treatment during early childhood at the University of South Florida. It was consistent with other information that I reviewed. And he was prescribed medicine primarily for attention deficit hyperactivity disorder. The defendant told me that during the childhood years there were multiple psychiatric hospitalizations at USF Psychiatry.
For what?
Well, basically all of the treatment for during childhood had to do with behavioral problems. Mr. Jonchuck was very aggressive with his family. He threw things, he broke things, he trashed the house. So the treatment had to do with all of those types of behaviors.
Okay. And you said he was taking medication for those behaviors?
Well, he was taking, yes, medication, at least for ADHD, Adderall, those types of medicines. There might have been other ones. I never was able to see specific information from records, rather, from the childhood psychiatric years.
Did he see any mental health experts subsequent to that time?
Well, he did tell me that during adolescence there were a few psychiatric hospitalizations as well, and he described those as being due to self-injurious behavior. On one occasion, I think it was about 14 to 16, he got into a fight with his father, and he climbed up on the roof and took a machete, and he was Baker acted, and part
What is
of it
a
was
Baker Act?
Baker Act is an involuntary psychiatric hospitalization. There was a real conflict between he and his dad, and he wanted to get out of the house, so that was a good way out for him. He told me that, again, there were probably 2 other psychiatric hospitalizations during the adolescent years that had to do with self-injury, and I know his mother reported one as well.
Does that cover all of the Baker Act type of situations he went through?
The last involuntary hospitalization was at age 18, and then he had the outpatient mental health treatment for, I believe, 2.5 years with Dr. Arthur.
When approximately did that begin?
I'm sorry?
When approximately did that begin?
I think that was April of 2011 through December of 2013.
Okay.
And when he met with Dr. Arthur, he was taking a variety of medications, but the primary ones that sort of settled in were Seroquel and Ambien, the 2 major ones. He was also prescribed Xanax. Again, there were other ones along the way, but I think as time went on, those were sort of the, sometimes I'm not a psychiatrist, but prescribing medication is a little bit of a touch and go. You have to find out what works. And I know the most important medicines towards the end, from the end of his treatment, were Seroquel, Ambien, and Xanax.
Why was he being prescribed those drugs?
Well, Seroquel can serve several purposes. It can be used for psychotic symptoms, or it could be used for mood disorder, primarily bipolar types of symptoms, depression, hyperactivity, agitation, poor anger control. When reading Dr. Arthur's notes, there were a number of notes that spoke to poor anger control. So Seroquel, that can be used for those purposes. Ambien is a sleep aid. Xanax is a typical medication for anxiety, and anxiety was identified by Dr. Arthur. I believe Dr. Arthur's diagnoses were bipolar II disorder, anxiety disorder, and ADHD, attention deficit hyperactivity disorder.
You said the defendant saw Dr. Arthur for a certain period of time. Why did it end?
Why did it end? Well, Mr. Jonchuck told me that he just stopped going, so they didn't, they terminated him. His mother told me that he wasn't paying the doctor. So those are the 2 reasons that were made apparent to me.
Did you look into his residential history?
Yes, I did.
Why would you do that?
Well, trying to understand more, about, again, relationships with people, where he lived, how things went in that aspect of his life.
Did you try to find out what kind of roommate he was, that kind of thing?
That was part of it, yes. He did live with roommates.
And what did you find about his residential history?
Well, he lived with his uncle and his uncles from age 14, 15. He stated from about age 15 to 18, he was living independently between different friends, so without adult supervision. He met Michelle Kerr when he was 16 or 17, began living with her on and off for 6 years, beginning at age 17.
Now, Michelle Kerr was the mother of Phoebe?
Correct, yes.
Okay, go ahead.
And after he separated from her, he lived with his father for a brief period of time. He procured the pre-settlement loans, bought the condo. He was there for about a year. As I indicated, that ended with a default and all of that. And then for about a year, he lived with different roommates between the homes of 4 or 5 people, and for a couple of months each, and he had Phoebe with him. And then beginning in September of 2014, Phoebe began to live primarily with Mr. Jonchuck's mother, and he continued to live with various friends until about November of that year.
Did the defendant and Ms. Kerr ever marry?
No.
How long were they together before they split up?
Well, they were together on and off for 6 years. You know, there was a lot of turmoil and instability in that relationship. So he would move out and then move back in.
After Phoebe was born, when he would move out, who would have custody of her?
He did, he did, but she would stay often with his mother or father.
Did you look into the different relationships that the defendant had?
Well, again, with his roommates, the roommates described very negative relationships that he was very difficult to live with. A lot of poor anger control, a lot of conflicts, very difficult in terms of being a responsible roommate.
You indicated before that you spoke to some collateral witnesses?
Yes.
Okay. We'd like to go through some of those witnesses that you spoke to. You indicated that you spoke to his biological mom?
Yes.
And what did you learn from her?
Well, I'm just going to read some of the things that she... As I was going to say, I'm just going to read some of the things that she told me. She indicated that Mr. Jonchuck could be nice when he wanted to get something, primarily money, but would very rapidly have very rapid mood swings where the niceness would turn into anger, particularly if he didn't get the money or didn't get his way. So she described him as frequently setting her up by trying to sweet talk, for lack of better terms, to get what he wanted, but frequently return to anger and just very negative type of relationship. And then again, she indicated that he would often put on a good show. So she described a personality that was not real authentic, put on a good show to get what he wanted from her, but then just use her for the money. She indicated that, I asked her, of course, about his early adjustment, that he was very smart, he was frequently on the go, he'd get depressed, and he would, as a kid, he would throw food. He saw Dr. Arthur, he didn't pay him, stopped the medicine, very poor with finances, and that Mr. Jonchuck would frequently, the term she used, blow himself up. By that she meant he would present himself as being very smart, knowing more than other people. He would have what we call kind of grandiose plans, like he was going to be a doctor or go to a hair school, but he would always drop out. He wouldn't follow through with those things. She indicated that as a youngster, there were pets in the home.
Council approach, please. It's a little shy of an hour. Thank you for your cooperation. We could pass on the chairs.
report, Your Honor.
Dr. Burstyn, what were you going to say?
I was going to say that she said that there were pets around and never would show any interest.
I didn't hear what you said, Your Honor.
Relevant to me, because he didn't show any interest in the pets. I know lots of people who don't like pets and who mean anything bad about them. Let's bring him back in, please. Thank you.
Judge, we
Can I ask
are-
can I ask the expert why he considered it relevant?
Deputy Gray,
Yes,
stand by.
hold on, wait, yeah, why did you
Well, I
consider,
would,
yes?
first of all, Your Honor, all due respect, I wouldn't bring it up if I didn't think it was relevant. Okay, so it's relevant because it has to do with the lack of attachment and bonding, and that's my interpretation as a professional.
So if you have a dog in your house, because some other family member has it, you're not interested in pets, what does that mean?
Well, it doesn't mean anything, like a lot of things don't mean anything in and of themselves, but there's very, very clear patterns here that are, in my opinion, very relevant to my understanding of this individual.
I understand that, but
Yeah.
it's highly, pets are a fuzzy, warm thing to bring up, and I think the probative versus the prejudicial far outweighs it. Let's bring him in, please. Oh, I sent him to lunch. Okay, that's right. Forget that. Is there anything else we need to address while?
Yes.
Okay. Dr. Burstyn can leave, right, for lunch?
Well, I don't know what they're bringing up, Judge. He may be necessary to answer questions.
Well, they'll know. Are you bringing up something that he would need to deal with?
I mean, we're asking the court to, but my understanding is the court's not going to inquire further, so no, we don't need him for anything.
Okay, thank you. See you back at 2:15?
Yes,
Thank you,
ma'am.
Dr. Burstyn. You can start.
Oh, okay. Judge, at this time, the defense is moving for mistrial. The last, I'm not certain how many minutes of Dr. Burstyn's testimony, but specifically regarding uncharged prior bad acts and specific examples of bad character evidence. He indicated that there were 7 to 8 in-school suspensions, that he was suspended for fighting, that he had disruptive behavior in school, that he was let go. There was a specific note regarding a specific instance that he was let go from a previous employer, being Humana, because he didn't show up. He testified that for the last year, he spent all of his money on drugs. He indicated that he defaulted on loans on the condo, which, well, I guess we're not even getting into the truthfulness of any of this yet, but that he had defaulted on loans regarding the condo, that he indicated he had a check machine, that he was printing fraudulent checks, defrauded his mother out of a lot of money, that he used Phoebe's money for drugs, that his roommates described having a very difficult situation with him, that his mother describes that he's nice when you wanted to get something, but he was described him as setting him up to get things. He would play nice to get what he wanted, and then would become angry and negative, that his personality is not authentic, that he puts on a good show to get what he wants. All of these are inadmissible. The state has not provided any line of cases that would suggest that this does come in by filing an insanity defense. I can tell you I have researched on end, and everything I pull up suggests that the exact same rules of evidence still apply in an insanity defense. And so at this point, we've asked for curative instructions on all. We don't think any of it should come in. If it's coming in, we believe that all of those individual things require curative instructions. They all came in. We didn't have any curative instructions. This is a character assassination. We're moving for mistrial.
Okay, you said you had a case that stood for the proposition that I have to give some type of Williams rule warning on a sanity case. Have you found that?
The issue, Judge, is any time.
Have you found that case that stands for the proposition that I need to give some kind of special cautionary instruction for bad acts to support a mental illness in a sanity case?
The rules say if you're letting in evidence of prior bad acts, that there should be a cautionary instruction given if requested.
I understand, but that is for Williams Rule prior bad act.
No, that is under 404. Anytime character evidence is admissible. So we're calling it Williams Rule, but just looking at the rule book.
Okay, but you said you had a case that stood for your argument that you have to do it in the Sandy case. I'm asking.
That you have to do an analysis. That it's the exact same analysis.
Well, you told me instruction. Have you found it?
No. The instruction I said was from an Alabama case. I said I have an example of a curative instruction that's given. That's in Vaughn. No, I've had it on my computer, but I haven't found the hard copies printed. That is a Supreme Court of Alabama case where it gives an example of the curative instruction that we would be requesting. The cases that I previously provided the court stand for the proposition that they still have to meet the same criteria to come in under 9404.
Well, I don't disagree with that. You gave me a Supreme Court case, 829 Southern 2nd 901, that says where the evidence of a collateral crime is being offered under the Williams Rule. This isn't a Williams Rule case.
Is that the one that it goes on to discuss whether the state actually files a notice versus not filing a notice?
I don't know.
It's the same. Whether they're trying to introduce the evidence, but they're trying to do it improperly by not filing a notice, that does not alleviate the issue of the court acting as the gatekeeper and still conducting the same analysis. If we're not put on notice, that's obviously something that we have to do mid-trial versus pre-trial. But that just because the state doesn't, I mean, it shouldn't be admitted because they didn't file the proper notice. But if the court's going to allow it, absent them filing the proper notice, we still are entitled to the court making the same inquiry and comparison of admissibility if they had followed the rule.
I respectfully disagree with you. This is not a Williams Rule case. This is a sanity case. And one of the foundations of one of the mental illnesses is certain traits that are consistent with an antisocial personality disorder. And I agree with you, not every single thing comes in, and that's why I stopped him with the pets. And the answer is pretty innocuous because he didn't have any interest in the pets. So to cure it, he could just say what the answer is, because I'm sure everybody's minds went to, you know, he pulled off the tails or punched out the eyes or something, and it's not that. It's he didn't care about it, or he had no interest in it. So what? And then just move on. I'm not going to allow him to say what that means. So anything else?
Yes, Judge,
okay.
The cited. Can I borrow your copy? I can't find mine right now.
Okay, what copy do you want?
Oh wait, hold on.
There's a page right here you left on the thing.
It's not that one. It's
No, those, I don't use those. Here's Bozeman, which I just read, which is
It's
nice.
Tollefson, Tollefson v. State. That's 525 Southern 2nd 957. That's First District from 1988. In this case, this was an insanity case. The facts are undisputed.
Is this a DUI case?
Mm-hmm.
Okay, well, we've covered that ad nauseum, and you used it to argue his two prior physical altercations with his mother, which could have been or not been a result of a psychotic break, and I ruled in your favor because I thought it was relevant that his mother had specified how he was acting before, and plus I said it was beating up your mother is, in the community's minds, I would suspect is about the worst thing there is. So
I
said, no, that's not coming in.
Okay, and this stands for the proposition, Judge, that they specifically say, In this case, during the trial, the state moved to present evidence of a collateral offense which occurred nearly a month before the present offense. On April 12, 1986,
Judge,
the
I object.
appellate was...
We've had, this is asked and answered,
Could you please yell at him and
argued,
swat him down?
nothing new is coming out here.
Could you please swat him to sit down and
SWAT team?
chastise him for
Ms. Manuel,
interrupting?
Ms. Manuel, sit down.
I was still speaking. He just stood up and started interrupting
I felt
me.
that's very unprofessional. Please sit down. We're going to break for lunch until 1:15. Thank you.
All rise. Being recessed.